She then manipulated their trust. She said, well, just give him a little bit of massage. Then Maxwell personally participated in these acts of abuse, including a 14-year-old Jane. Disgusting. At the end of the testimony, the agent testified that he or she had not disclosed everything, only responding to these questions. Grand jury came back in, indicted. Wow. It's a mop-up operation. The materials do not identify any other person other than Epstein or Maxwell as having had any contact with a minor, obviously, because it wasn't investigated, or at least by Comey. Grand jury records denied. You see, out of the Southern District of New York, we have a new opinion and order that have come down in the United States of America in the prosecution against Ghislaine Maxwell. The judge on this one is called Paul Engelmeyer, and we're in the Southern District of New York, which is where Ghislaine Maxwell's trial was. Of course, she was convicted, and she's still in prison, although it's minimum security prison, and they gave him some dumbbells, and she's out there with that Holmes woman, not exercising, it looks like. And here is what he says in response to the efforts to unseal all of this. He writes, on December 29th, a jury convicted Ghislaine Maxwell of 5 felonies involving the abuse of young girls that she and notorious PDF file called Epstein committed between 94 and 2004, right? A jury. Now, the decision involves, the government's motion from Todd Blanche back on July 18th to unseal the grand jury transcripts, and then they supplemented that later to unseal the exhibits. And we've had questions about that because it didn't really sound like they wanted the exhibits at first, just the transcripts. The exhibits are going to have some juicy stuff in there, no doubt. Subject to redactions, of course. Now, for the reasons that follow, the court denies the motion. And we're not surprised by that. I think we're correct in our assessment of the prior filings, saying that it looked kind of almost like a token effort from the DOJ, just, the public won't shut up about this stuff. So, Your Honor, they even wrote that in one of their original filings. While we don't think there's going to be anything new in there, the public has a lot of interest. And you're like, oh, thank you for the effort and the heft behind your request. So here's what the judge writes. In late November, prompted by investigative journalism, the United States attorney in this district opened up an investigation into Epstein and his co-conspirators in November 2018. There was a journalist who wrote about it, right? Some journalist apparently did way more work than the FBI did and exposed his many layers of crimes that he's been covering up for years. And so they wrote about it. So then apparently, according to their story, the DOJ got public pressure, and so Epstein gets indicted. All right. On July 2nd, 2019, a grand jury charged Epstein in violation of the law. On July 6th, he was arrested, and then just over a month later, Epstein died by suicide. On June 29th, the grand jury in this district, so then Epstein's dead. 2019, public still outraged. Nobody believes the Epstein story, so they're like, well, okay, fine. We'll just go get Ghislaine Maxwell, and we'll just call this a day. We'll button her up. We'll tie up all the loose ends and be done. Now, a grand jury in this district returned a 6-count indictment against Maxwell, saying she facilitated a bunch of things with Epstein. She got conspiracy to entice minors, enticement of a minor, conspiracy to transportation of a minor with intent, and a bunch of other crimes. Now, it based these charges on conduct with 3 minor victims between Ghislaine and these persons. The government identified pseudonymously. Now, on July 8th, 2020, the grand jury returned another indictment, which made some ministerial corrections, minor things. On March 29th, a different grand jury returned a second superseding indictment. It also added 2 counts and a 4th victim, who also was pseudo-anonymous. Now, one charged a sex trafficking conspiracy. The other was trafficking of a minor, and it broadened the time period as well. Okay, it went all the way back to 94, 97, all the way back up to 2004. So then trial started. We covered a lot of it before the Honorable Allison J. Nathan. And Nathan now has gone up to the 2nd Circuit, and so she's right next door to Emil Bove. He's in the 3rd. So to whom this case was then assigned. And a jury on 6 counts in the S2 indictment, all but the 2 perjury counts. It ended. She got convicted of 5 of the 6 counts, and she was acquitted on enticement. Now, the evidence adduced at trial is well summarized in the trial judge's post-trial decision. We covered a lot of this, denying Maxwell's motions, right? She said, actually, there was a fatal flaws that occurred in the trial. I'm innocent. Here's why. You should grant me a judgment of acquittal. Judge Nathan responded, said, no, actually, here's what happened. And in brief, the court will recount it for us. The government's evidence included the testimony of 4 women who described the abuse they suffered at the hands of 2 people, Epstein and Maxwell. Now, the testimony of individuals who worked for Epstein and Maxwell, we covered a lot of them. The testimony of law enforcement, physical evidence, photographs, searches of Epstein's residence, the black address book, corroborating records, private flight logs, FedEx records, and more. The trial evidence focused on 6 girls, 4 testifying victims who suffered abuse at their hands: Jane, Kate, Annie, and Carolyn, Virginia, and Melissa. It established that Maxwell had been instrumental in approximately a decades-long scheme with Epstein to entice, groom, transport, traffic women and underage people to Epstein. And it's like they did it themselves. I guess Ghislaine Maxwell was the taxi driver. She transported all these kids by herself and groomed them by herself and trafficked numerous numerous people, like on airplanes. I don't know if she's a pilot, maybe. Maxwell helped identify vulnerable girls for abuse, targeting those who faced difficult family circumstances, including financial hardship. She would befriend the girls. She then manipulated their trust. She'd say, well, just give them a little bit of massage. Then Maxwell personally participated in these acts of abuse, including a 14-year-old Jane, disgusting, instructing her on how to touch Nathan's hot dog during a massage and touch Jane's breast herself. So did they actually do it? All right. So she participated in acts of abuse, for example, instructing her on how to touch it. Okay. But did she actually go do that? Or, I know it's not appropriate conversation, but I think there's more egregious examples of that than a conversation between Glenn and a 14-year-old Jane, as disgusting as that is. Now, Maxwell and Epstein also paid young girls hundreds of dollars of cash in exchange for being abused. Once a girl was introduced to these massages, she was offered more money if she brought other girls to engage in those sexualized massages. Now, Maxwell also fostered a culture of silence there, saying, see nothing, hear nothing, say something, is what she directed employees to do. All right. So then, on January 19th, Maxwell said, I need a new trial. First of all, one of the jurors lied when he came in and was getting on the jury panel. Remember, there was a question there, have you been subject to sexual abuse? He's like, no. After the trial, he's like, yeah, I can't believe that one time that I got abused. You're like, what? On April 1st, after a hearing, the judge said, well, it doesn't matter. He was still a good juror. Maxwell made other motions. The judge denied all but one. And she said the 3 conspiracy counts were multiplicitous. So she just said entering a count on one of those, but she still sentenced her to a long time. 8 victims submitted victim impact messages. Nathan imposed an above guidelines sentence. All right. So there's charts and basically spreadsheets and go like this. Over here, put them right here. This is your penalty. This is the range. They said she actually went above the guidelines, sentenced her harsher. Maxwell, she stated, directly, repeatedly, and over the course of many years, participated in a horrific scheme to entice, transport, and traffic the girls. As an example, she noted, after Caroline had confided in Maxwell her personal story of having been arred and molested by her grandfather, Maxwell used that knowledge to continue the cycle, inducing her to give the massages for years, and by herself touching her breasts when she was 14 years old. Yeah. All right. So Judge Nathan also noted that Maxwell had repeatedly deflected and blamed and lied about her offenses, including a civil deposition and a pretrial services in the court. It's like, that's what Maxwell did? She touched a 14-year-old's breast? As horrific as that is, wasn't there a lot worse than this, than just the massages? I don't know why the judge is framing it this way. It's a little strange. Appeal. On February 28th, Maxwell appealed her conviction and sentence. The Second Circuit affirmed. It said that the judge's holding, and we've talked about this a lot, the 2007 non-prosecution agreement, the argument is not valid. So the non-prosecution agreement does not immunize Ghislaine Maxwell. I think that the intention of that non-prosecution agreement was absolutely to protect Ghislaine Maxwell. Why would it protect Epstein's number 3, 4, 5, and 6, but not his number 2? Doesn't make any sense at all. They also said the indictment was timely. They said juror misconduct is not a reason for a new trial, and also the jury questions were not answered incorrectly. On April 10th, she also petitioned to the Supreme Court of this year, saying the non-prosecution agreement applies to her. We'll see what SCOTUS does. Here is the latest on this disclosure now, okay? So that's the background. On February 27th, the DOJ issued a press release. It stated, we had declassified and were publicly releasing files related to the exploitation of more than 250 girls. Quoting Pam and Cash, they said this back on February 27th. The judge writes this. This DOJ is following through on President Trump's commitment to transparency and lifting the veil on the disgusting actions of Jeffrey Epstein, said Pam Bondi. The first phase of files released today sheds light on Epstein's extensive network and begins to provide the public with long overdue accountability. Dud. The FBI is entering a new era, says someone else, one that will be defined by integrity, accountability, and unwavering pursuit of justice, said Kash Patel. There will be no cover-ups, no missing documents, no stone left unturned, and anyone from the prior or current bureau who undermines this will be pursued. If there's gaps, we'll find them. If records have been hidden, we will uncover them, and we will bring everything we find to the DOJ to be fully assessed and transparently disseminated to the American people as it should be, but we're definitely not going to hire back Garrett O'Boyle, an FBI whistleblower. Definitely not going to do that, though, so everything else will be good. All right, so here, the judge is saying, this is very curious, right? The judge is rubbing their noses in it, as he should, because this was ridiculous. And in the same press release, the DOJ quoted a letter from the AG to the FBI director. The AG said that we had just learned, remember Pam, we had just learned that the FBI possessed thousands of pages of documents related to Epstein. Her letter continued. She said, we read this here. Remember she sent this over to Cash? By 8 a.m. tomorrow, Cash, the FBI will deliver the full and complete Epstein files to my office, including all records, documents, audio, video recordings of Epstein and his clients, regardless of how much information was obtained or how you got it. There will be no withholdings or limitations to me or your access, the DOJ will ensure that any public disclosure of these files will be done in a manner to protect the privacy, which she's done her entire career, says Pam. I appreciate your immediate attention. The American people want transparency. They said it all. Like, so when we get mad at them and we're like, you guys are acting like fools, we're just holding them accountable to their own words. That's all. On July 6th, the DOJ and the FBI issued a memo, right? This was the ridiculous one. As part of our commitment to transparency, we reviewed 300 gigabytes of data, which is like, cell phones have like 1 terabyte of data now or whatever. It's crazy. It's like nothing. 300 gigabytes based on everything that's been going on for decades of criminal investigations. It's ridiculous. It makes me so mad. The files relating to Epstein include large volume of images of Epstein and videos of victims who are either minors or appear to be minor. Over 10,000 downloaded videos. All right, just to be clear, just do the math on that. 10,000 videos. How many gigabytes is that? Only a fraction of this material would have been aired publicly if this had gone to trial. They're just calling it's just regular, CP is basically what they're saying. The systematic review revealed no client list. And so to that end, we're done. Remember that? We read it. Everyone flipped out, us included. Now the memo included a hyperlink. We watched the video, which was completely foobarred, and it was not even close to being the raw footage that they claimed it was. Looks like somebody made a screen recording of it and then sped the video up and then deleted a minute of the time. Actually, and I think if you do a deeper assessment on that, it's more like 8 minutes of the video are missing, depending on how you analyze it. Now, ensuing news accounts reported that the public and Congress were pretty not happy about your little memo and called for the release of the records. So motion to unseal. They say now Todd Blanche filed, look, a 3.5-page motion. And that's the judge calling them out. We said the same thing. We're like, what is this? It's like 4 pages. On July 6th, they said, we issued a memo. They write, while the DOJ and the FBI continue to adhere to the conclusions in the memo, meaning we don't think there's anything here, Judge. Transparency to the public is very important. And because the public wants to know, we ask that you unseal. We said this was the weakest reason you've ever heard because the public has some curiosity. Judges don't care. The motion noted that the Second Circuit had recognized special circumstances. Now, on July 22nd, after the case was reassigned, the court issued an order saying, I need some more information than your 3.5 pages there, Todd. So can you flesh this out? File a real motion? It ordered the government to file a memo addressing the factors in the case that you referenced, because you referenced the case. You said I have the power to do it. You didn't do any analysis on it. So do some analysis and file that later. The order also gave Maxwell an opportunity to respond. And Maxwell, of course, objected to it because she has an interest in being the sole purveyor and holder of the key. She controls the information as it stands. And if the grand jury comes out and either we get something useful and substantive that makes her less valuable, or if we come out, it gets released and the public says, oh, there's nothing there and moves on, then she's less valuable. So she wants to keep the record under seal, obviously, and she's said such in her filings. On July 31st, the court directed the government to also file more. Do you want the exhibits too, or just the transcripts? And what parts of the transcripts are not already public? Then on August 4th, Trump's DOJ responded. They said, okay, some of it is not actually public. They filed under seal. Now, Maxwell filed a letter opposing the unsealing. Then the next day, the court docketed a bunch of victims' letters and some other stuff was filed under seal. Now, the judge is going to explain the general rules. Federal rules of criminal procedure, okay? It's pretty common. Grand jury proceedings are secret. It's just part of the law. It's how it's been forever, and it's how it's always probably going to be. Now, the rule of secrecy was codified, and it says you don't disclose any of these things. But then the courts came out and they're like, well, the rules are made to be broken, and so, there could be some special circumstances that don't actually exist in the rules. And so the Second Circuit developed this doctrine in 3 cases where disclosure was sought of grand jury matters that were of unusual historical or public interest. And it's based on some other authority, like an administrative power that's inherent in the courts. Now, it's recognized in 2 circuits, but not elsewhere. The Second Circuit set out 9 factors, and we've talked about them. Who wants it disclosed? The DOJ. That's pretty important, right? It's not Rob Gouveia sending in a letter. Your Honor, can you unseal the grand jury transcripts? They're like, no, get out. All right. But if you're the DOJ, it's a whole separate issue. Whether the defendant to the grand jury proceeding opposes it, Ghislaine Maxwell does, why disclosure is being sought, what specific information is being sought, and the other factors. The doctrine should only be applied in exceptional circumstances, and it's not for garden variety petitions for disclosure, okay? We protect these things. No exception to the rules. Trump's DOJ authorizes the government to disclose this material. None of it. The government's motion to unseal doesn't contend otherwise. It does not argue these materials would aid anybody, federal, state, military, or local law enforcement, federal law enforcement. No, No, because they're not going to prosecute anybody. So the judge is saying that's not a good reason. Okay, is it relevant to national security? No, they're not going to look at it. Another grand jury? No, no one else is getting indicted. Another judicial proceeding? No, Epstein's dead. Nor does the government or Maxwell argue the materials could dismiss the case against her, so is it like unjust for her? No. Any such motion to dismiss today would also be futile because Maxwell's conviction at trial renders all but the most serious errors harmless, right? So it's hard to get out of a conviction. So the government instead says, well, there's a special circumstance on the ground that there is an abundant public interest in obtaining information about Epstein. It states that attention given to the Epstein case is recently intensified, and we don't care, but the public wants to know. And the government says that these are just critical moments in history, and so that's enough. Now, the government's invocation of special circumstances saying this is really important, though, it fails. Its entire premise that the grand jury materials would bring to light meaningful new information about their crimes, it is demonstrably false. There's nothing in there. The court says, after we got the government's motion to unseal, we said, give us the materials that you think are in there that are historical or public interest. Specifically, the court ordered the government to submit the transcripts and the exhibits to the judge for an in-camera review, off the record, kind of in the judge's chambers behind the scenes, with the portions of the government proposed to redact to be highlighted. And it ordered the government to file a submission identifying the portions of the transcripts that are not already public record. Now, the submissions were telling, says the judge. They belied the government's claim in its motion to unseal that the grand jury materials contain significant undisclosed information about their crimes or the investigation into them. Two features of these materials which were not disclosed in the government's motion are noteworthy. Interesting. The court reports these here at a level of generality that doesn't disclose the substance. First, the grand juries in this case were not used for investigative purposes. They did not hear testimony from any first-hand witnesses to any event at issue. They did not hear testimony from any victim, eyewitness, suspect, or even a records custodian. The grand juries met instead for the quotidian purpose of returning an indictment. So they're listening to cops, essentially, right? FBI agents, didn't hear from victims. So it's cops coming in, FBI people and prosecutors asking cops questions, and that's it. So no suspects, no eyewitnesses, no victims. It's just official government people presenting to the grand jury. That's all. All they're doing is returning an indictment. They're not trying to convince a judge to go issue subpoenas for something or other. We got enough probable cause here to charge this person. We just need a grand jury to sign off on it. Each grand jury got evidence on a single day. Boom. Because this was a mop-up operation from Maureen Comey, which is why it was this way. This is good evidence of how it went down because we can't see or know anything about the grand jury proceeding. So this gives us some good clarity on just how pathetic the case was. They impaneled the Ghislaine Maxwell grand jury and buttoned this whole thing up on a one day with a grand jury. Insane. On that day, it heard testimony from one person. That's it. A law enforcement agent who, acting as a summary witness, testified to information obtained in the investigation to support the charges in the proposed indictment. They brought one cop in. The agent, responding to tightly structured questions from the prosecutor, Maureen, provided highly abbreviated hearsay accounts of the statements of select witnesses, the victims on whom counts in the proposed indictment were based. The agent led the jury through PowerPoints, photographs, and business records. At the end of the testimony, the agent testified that he or she had not disclosed everything, only responding to these questions. Grand jury came back in, indicted. Wow. It's a mop-up operation. That's exactly what this was, okay? And they didn't even want to investigate anybody else or present more evidence to go after other people. They just needed Ghislaine. They brought in one dude. The agent's testimony was an hour and a half, like a bad movie, and it was 74 double-spaced transcripts pages. Two exhibits were put before the grand jury, a PowerPoint with their little book report and the proposed indictment of Maxwell. The same grand jury met again. They returned a superseding indictment. It corrected two typographical errors, and they did not receive any additional evidence. This is wild. So there's nothing in there. And you know what? The DOJ knew that too, and they're filing all this too. The second Maxwell grand jury also met in 21. It heard testimony from New York Police Department detective. The detective's testimony lasted approximately an hour and 48 minutes, brief recess, 117 pages. 2/3 of that testimony consisted of reading into the record the special agent's 2020 testimony. Okay, so the new grand jury is just a guy reading what the other guy said. Our system is so crazy. 6 exhibits were put before the grand jury, the transcripts as well, the PowerPoint, and a new PowerPoint. Those were the exhibits. It's like, it's not a trial, right? You don't have to present all of the evidence, but this was a target for Ghislaine. This wasn't an investigation into a pedophile ring. They needed to sideline her and shut the public up and get her off the board because people were wondering, where is she? Remember, she was fleeing around, hiding out in mansions. Second, the evidence put before the Maxwell grand juries today, with only very minor exceptions, already public record, says the judge. The government admitted as much. The government even said the enclosed annotated transcripts show that much of the information was already publicly made available. Same info, because they actually came and testified. So the exception, it noted, does not reflect the information the public would learn were the grand jury transcripts unsealed. So there's just not much in there. The court's review confirmed that the unsealing of these materials would not reveal new information of any consequence, okay, which is what we suspected because this was a mop-up for Glenn. That's all. In response to the court's order, the government supplied the court with a binder highlighting any information that had been unable to determine is public. There's only scattered words and clauses, and occasional sentences are highlighted. These items are few and far between. The highlighted snippets supply at most tertiary details about her trial. The same is so for the exhibits, except for inconsequential portions of a few exhibits. These were all received in trial. Some were even reproduced in the indictments. And so a member of the public familiar with the Maxwell trial record, as we are, who reviewed the grand jury materials, would learn next to nothing new. The materials do not identify any other person other than Epstein or Maxwell as having had any contact with a minor, obviously, because it wasn't investigated, or at least by Comey. They do not discuss or identify any of Epstein or Maxwell's clients. They do not reveal any heretofore unknown means or methods of their crimes. They do not reveal new venues at which their crimes occurred, no new sources of their wealth, no new circumstances of Epstein's death. They don't reveal the path of the government's investigation. There's nothing in there. And so as far as the motion to unseal implies, right, so Todd Blanche is saying, Your Honor, there's an untapped mine of undisclosed information. He says that is definitely not true. All right, this is all the same crap you guys know. A public official, lawmaker, pundit, ordinary citizen who reviewed these materials is not going to learn anything new. They would come away feeling disappointed and misled. Well, that's okay, because we're already feeling that way anyways. So there is no there there. Oh my gosh, who wrote that? There is no there there. Didn't Dan Bongino say that too? Dan, is that you? This case is thus a far cry from every reported case applying to the Second Circuit special circumstances doctrine. There's nothing special here at all. In such a case, the petition to unseal, whether granted or denied, is usually undisclosed information, but everything here is already disclosed. These other cases were important, but you, from the Trump DOJ, have not cited any finding that any materials satisfy the standard here because there is none. The one colorable argument under that doctrine that might be useful for unsealing is that doing so would expose as disingenuous the government's public explanations for moving to unseal, right? A member of the public appreciating that the grand jury transcripts do not contribute anything might conclude that the government's motion for the unsealing was not aimed at transparency, but at diversion, aimed not at full disclosure, but an illusion of such. The judge is dead right about this. And there is precedent in re Briagi, the fountainhead of the Second Circuit special circumstances doctrine, permitting a court to order the release to correct the movement's misleading public characterization of it, right? So Todd comes in, Your Honor, there's a bunch of important stuff in here that the public wants to know about, so give us this information. The judge says, actually, no, there's not. You said there was, because you want to pretend like you're doing something useful to disclose this stuff, and you're explaining it in a way that's not true. So now I will release it so that everyone can see that you're a liar, kind of a thing. Now, I don't think that that is appropriate here. Like, you can see that in certain circumstances where somebody says, well, that person is making these claims or whatever. You go into some specifics of the allegations in the grand jury proceedings that you might want to challenge. But here we continue. They explain another case about this dude called Biaggi. And now we're back. The court gave careful consideration to unsealing the materials, but with the government having now conceded the information is already public, the public interest doesn't require it. Without any need to review these materials, the public can evaluate for itself whether the government is being honest with us or not. We know what's going on. The court therefore denies Trump and the DOJ's motion to unseal at the threshold. Maxwell's grand jury testimony is not a matter of significant historical or public interest. It's far from it. In fact, it consists of garden variety summary testimony by only 2 law enforcement agents. And that information it contains is already almost entirely a long-standing public record, principally as a result of live testimony by percipient witnesses at the trial. So it was like the most basic indictment ever because they just needed to get her indicted. That's all. Just make a PowerPoint. What should I put in it? Whatever you want. In cases involving grand jury testimony, there's other frameworks, but here there is an interest in secrecy, not that is overweighed by the public interest. This factor also carries great weight. Who is seeking to release it? This factor favors disclosure, right? Because it's the DOJ saying we want this released, but we're going to cabin that off for a little bit. There is no information inside that's not already outside that's meaningful. So that's why that factor doesn't matter. Now, second, any argument that the motion to unseal merits deference. Actually, the motion is not joined by the government's trial team at all. The DOJ lawyers, presumably most familiar with the case, are not on this. The motion was filed by Todd Blanche without any signatory from the U.S. Attorney's Office in the district, and it was made under circumstances circumstances suggestive of haste rather than reflective deliberation, which we said the same thing. The motion was 3.5 pages in length. There were no supporting materials filed, under seal or otherwise. The motion did not disclose or reflect awareness of the summary witness nature of the Maxwell grand jury testimony. That's true too. I was like, there's a lot of good stuff in there. Like, no, it's not. It was an hour and a half. It was like 2 hours of testimony. There's nothing in there. It was one probably lady in a PowerPoint. And the motion was made without advance to Epstein or victims, a fact which was reviewed also alarmed the victims. Only after the court inquired on that point was notice to victims even given. Finally, the government highlighting of the grand jury transcripts did not suggest a close familiarity with the record at all, because the number of details identified as non-public actually were public. Maxwell opposes disclosure too. Her case is on appeal, and so this weighs against unsealing, but it's limited weight. Her opposition is viewed as precautionary. If she had been aware that the materials were duplicative, her position might have been different. Now, another factor is, why do we want disclosure? This is against unsealing, right? This is the same point we made. Public interest, not a real good reason. The government makes broad proclamations about the public interest in learning more about this. That interest is undeniable, but the government has failed to connect it to the material issues, which would not answer any of the public's questions because the grand jury, right? The judge hasn't said this about how like basic the grand jury was, but he's kind of implying that because he doesn't want to invalidate basic grand juries, because a lot of people get indicted through basic grand juries like that. Here, the government does not seek tailored disclosure, nor does it seek to disseminate to a specified audience. They just want it released. And so since it's such a broad releasing, that weighs against unsealing. But the Second Circuit says timing is also important. Grand juries met 5 years ago, but her conviction is still on appeal, so it's still open. The other factor is the status of the people who were in the grand jury. Now, there weren't anybody. Okay, this factor wants to protect the reputation and the interests of unindicted individuals, okay? People who came in to testify about what they knew to determine if there's probable cause or not, about whom unsealed testimony would reveal damaging info. But there isn't anybody. They didn't even bring the victims in to talk, just some fed. Insofar as Maxwell was the subject of testimony, this factor there's nothing here. It's about her, really. She's alive, and so theoretically she could be harmed, but she's the only one. No one else is really even relevant. Now, we also have this prong, which is materials already been made public. Judge says, yeah, substantially all the information has already been revealed at trial, and there's nothing new. And both law enforcement agents who testified are alive. The government says, how about we redact their names? And this factor is neutral about the need to maintain secrecy. And what about the victims? Now, the court has received and reviewed with care and great respect letters on behalf of the numerous victims. Their letters address whether they want these things disclosed, and we saw there was a split. They also expressed broader concerns about recent government actions related to this. The letters in the main urge broad disclosure of the government's records, and consistent with this view, they generally support the release of the materials, provided that they're redacted. And so this factor favors unsealing, but there is an important qualification here. It's about new information. The government said that there are new pieces and critical pieces of important history, but this is different because there isn't anything new. Various letters also express alarm about the move of Maxwell, but court says, I can't deal with that, right? That's up for the political branches to deal with. Now, finally, is about systemic grand jury secrecy. And of course, they're almost always secret. This factor weighs heavily against unsealing. Granting the motion would bloat the special circumstances doctrine, and this is not a special circumstance. So for all those reasons, the government's motion to unseal the grand jury materials in this case is denied. The clerk of the court says terminate the motion at the docket. So that's the end of that.